Okay, good afternoon, everybody. Thank you all for being here today as we talk about the very important issue of trauma, what trauma is, how it impacts so many of the clients we serve, and strategies for how we as advocates and lawyers can build stronger, more trauma-informed relationships with our clients. My name is Jaya Connors, and I'm the director of the Family Violence Litigation Clinic at the Justice Center at Albany Law School. And before I introduce our presenters, I do want to advise those of you who have experienced trauma, some of the issues that will be discussed today may be triggering for you. If so, please step away if you need to. Take a deep breath, do what you feel best serves your interest, and let us know how we can support you. And onto the program. I'm so pleased and honored to introduce our expert presenters who will speak about the critical issue of trauma and offer insight and guidance into developing a trauma-informed lens. All of you have been provided with the speaker bios, so I won't take up valuable time going over their resumes. Our presenters today are Kayla Snyder, who is a crime victims case manager at the Albany County Crime Victim and Sexual Violence Center, attorney, artist, and abolitionist Lorelei Williams, Mary Armstead, who is a staff attorney at the Legal Project, and last but not least, Jelena Guo, who is a senior attorney in the Immigration Law Clinic at the Justice Center at Albany Law School. Again, thank you all for being here on this very beautiful day, and I will turn the program over to the presenters.
I'll share my screen, and then Kayla, I will let you get us started.
So we're going to talk a little bit about what trauma is, how it manifests, and I'll touch a little bit on ACEs in childhood. So what is trauma? Individual trauma can result from a single event, a series of events, or certain circumstances that individuals experience. The event may have been perceived by the individual as physically threatening, emotionally harmful, or life-threatening. Trauma has a lasting effect on an individual's functioning, including their physical, social, emotional, and spiritual well-being. The 3 E's of trauma are event or events, experience of the events, and effects of the events. Next slide, please. Breaking down the 3 E's. An individual experiences an event that they recognize as harmful to their physical or psychological well-being. Events such as 9/11, COVID-19, sexual abuse, domestic violence, a car crash. The individual is impacted by the event and the brain responds accordingly. The experience of the event may or may not create a lasting effect for that individual. I see that there's some feedback, I'm sorry. Trauma responses may vary from person to person, and individuals may experience a variety of symptoms related to the trauma. Next slide, please. Effects of trauma can include feelings as well as psychological symptoms. Feelings may include powerlessness, helplessness, shame, guilt, horror, emotional numbing or detachment. We see this a lot in sexual assault cases. Psychological symptoms may include PTSD or flashbacks, depression, irritability, anger, fragmented memory of the event. It's different for everyone. Next slide. What happens to our brain when we have a traumatic event? Our brain becomes disorganized and overwhelmed. The amygdala detects the threat and activates our flight or fight reaction. The sympathetic nervous system is also activated. The response is quick and automatic. Our prefrontal cortex, which is responsible for regulating our emotions, becomes less activated. This impacts our attention, awareness, decision-making, and voluntary behaviors. The prefrontal cortex protects itself. when the amygdala activates, sometimes by disassociating and blocking the memory. Individuals may become unaware, and consciousness can also be impacted. Trauma can have a lasting impact on developing brains. Next slide. ACEs, or adverse childhood experiences, occur during our development from 0 to 17 years of age. There are 3 types of ACEs. Abuse, which can be neglect. Abuse can be physical, sexual, or emotional. Neglect can be physical or emotional. And also household dysfunction, which includes prevalence of mental illness in caregivers, witnessing abuse, witnessing violence in the community, substance abuse, divorce, suicide, incarcerated individuals. ACEs can have an impact on developing brains. ACEs should serve as a guide to recognize the risk factors for developing health problems down the road. Generally, the higher the ACEs score, the more likely someone is to develop chronic health problems, such as headaches, depression, anxiety, PTSD, and it can even impact future victimization. ACEs can also negatively impact education and employment in the future. ACEs do not take into account positive experiences or healthy diet and exercise. Women and people of color are at greater risk of experiencing a higher ACEs score. I know Lorelei will speak more in future slides about the impacts of trauma and race and poverty. Next slide. Re-traumatization can occur from experiencing triggers. Triggers can be unpredictability, a change in schedule, transitions, loss of control, feelings of vulnerability, sometimes even positive attention from individuals. Triggers can be getting intimate with a new partner. We've seen a lot of people be triggered by the isolation of COVID-19 as well. What are some signs of clients being triggered? They might be jumpy or lash out. They might have difficulty answering questions. They might tell you that they can't remember. They might shut down and go somewhere else. Sometimes they'll express that they don't remember something or give very brief narratives of their situations. I think that's my last slide.
Great, awesome. Thanks so much for that background on trauma. And what we're going to do is we're going to dive in a little bit more deeply as to how this can intersect with your clients, particularly given the intersections of race and poverty and other intersectional issues. Next slide. Great. So I want to be very, very clear about something here as I talk about some of these very complex topics. What I am discussing with regards to race and other issues is very much a superficial introduction that is necessary for us to at least have a more nuanced view of trauma. It is by no means even amounting to a race 101. So if any of these concepts are new to you, if you have not heard about them or read about them in academic settings or in articles or in journals or anything like that, I would strongly recommend that you do a little bit more research on your own to get a deeper understanding, because what we're going through is really kind of more of a superficial level. Now, when we talk about race, I know everyone always hates this, is, you know, race is not real, it's a fake thing. And then what does that mean for us, right? And what we're not doing is we're not minimizing the effects of race. In fact, what we're talking about is that race, as we see in our work as advocates, is a social construct or idea that has been built over time, continues to evolve and change, but very importantly, it has concrete ramifications for people's lives, and it has very many interconnecting sides or facets. And the process of racialization is one way that our society sorts communities and people to allocate resources and access to resources. So to kind of give you a little bit of more background on what we mean by this is, if you've heard of, for example, redlining. Redlining is when we're talking about how communities, generally communities of color, tend to be isolated to specific pockets of communities where there's less access to resources such as public transportation, there's food deserts, not enough grocery stores. Maybe you'll notice driving around, you'll notice an abundance of pawn shops and furniture stores or payday loans. And so when we're talking about racialization and we're talking about these resources, and when we have access to them, when we don't have access to them, we're talking about those very real ramifications that we see for people's lives. Next slide. The other kind of side that's related to race is that of implicit bias. And now before I jump into implicit bias, I do want to lay out just an additional foundational concept that I think will be really important here. First, there's also 4 levels of racism that we kind of tend to define that helps us think about how racism can show up in our different contexts. On those 4 levels of racisms, we have 2 that are considered kind of individual level, and then 2 that are kind of more systemic and structural. When we're talking about like an individual level of racism, we're talking about, for example, one level is interpersonal or internalized racism, where, let's say, for me as a person of color, maybe I have coping mechanisms. For example, I constantly hold myself to a standard of perfection because of the expectations that have been put on me by the society within academics or with the workplace or something like that. Or maybe my form of internalized racism is that I have a prejudice against a particular, race, and maybe I just cross the street when I see someone of that background or something like that. So that's one form of racism. Another form of racism is interpersonal racism. And that's what we think about as lay people, kind of 2 people being racist towards each other. So one person saying something explicitly racist to another person. That is what we call interpersonal racism. Now, as advocates and as lawyers, what we really want to think about as well is really the racism that occurs on the systemic levels. Now, we have structural racism that, institutional racism that happens within institutions. So like, let's say, for example, that my nonprofit that I work at tends to favor, only white European descent clients for some reason, and like a specific type of petition or something like that. Or maybe we don't engage in debiasing for a case selection, and so we end up always taking the same types of cases from the same population, even though we know there are people who need our services who don't have that same access. So that might be an example of institutional racism. And then we have structural or systemic racism, when you have all those institutions and all those different layers working together in tandem to kind of create that redlining that we're talking about in that last slide, that creates this world that's highly racialized and creates this access and denial to resources that frequently falls upon on racial lines and divides. Now, when we're talking about implicit bias, we're talking about the interpersonal and the personal level in how we process information ourselves and how we interact with each others. And so when we're talking about implicit biases, we're talking about those attitudes and those stereotypes that affect our understanding, our actions, our decisions in a very unconscious manner. And so we're talking about things that are activated completely involuntarily and without our awareness or intentional control. Now, this is really important for me to highlight just right now for a second, is because frequently when we talk about implicit bias, or we talk about racism, or we talk about racist outcomes, within our work or in our workplaces, these conversations can get very heated and people can become very defensive because we can say, well, it wasn't my intent to be racist or to create that outcome that has a disparate racial output. But what we need to understand, though, is that because we all grew up in this highly racialized society that really controls access and denial of access of resources based on racial lines, all of us have internalized that. And that is what then impacts our ability to have implicit biases, right? And this is something that happens to all of us, regardless of our skin color, because we have all grown up in the same very, very complex society that has very complex race dynamics. And so it's important that we understand that these biases are very pervasive and everyone possesses them. And so we shouldn't be confronting these biases with shame, and instead thinking about what can we do to understand our biases and to prevent choices that might be affected by the biases that we have, right? And in fact, what I would also really suggest for folks to do is, we don't usually see these in legal trainings, but there are some great courses on Udemy and other online platforms on cognitive biases and debiasing techniques. There are, in fact, a whole field of study in psychology just on implicit biases and how they're malleable, and whether we can unlearn them through debiasing techniques. And so by learning and accepting all of these, this can also help us just to understand the context that we're working in when we're working within our offices, with our clients, and with our colleagues as we're all relating to each other. Next slide. Okay. So the other thing that is really important to talk about and think about within these contexts, as we think about the context that we're meeting our clients is racial trauma. What does that mean? And what does that look like? And what does intersectional oppression look like? Now, we heard a great description of how trauma can show up in people in a clinical sense. But let's take a minute and kind of really think through what this looks like in the work with our clients, right? So to give you an example, I just want to talk to you for a minute about a client of mine who we'll just call him Sam for the sake of this. And Sam is he's a giant human being, more than 6 feet tall. It's a very impressionable thing for me because I'm only 5'2". So I noticed height quite a bit. And so Sam, he had a prior domestic violence conviction that was actually went to straight probation and was not really supposed to be a thing, but Georgia has like really stupid sentencing sheets from their criminal courts, and so it turned into a whole big mess. And in any case, he ended up getting apprehended and sent to ICE detention in Georgia, and he's actually been at multiple detention centers. And what was important about having a trauma-informed relationship with Joe was that our case went a million different places. So first, his case was denied by Georgia judges, and he went to the BIA twice. He's still at the BIA for the second time. And without a understanding and a strong relationship with my client, Sam, who knows if he would have stuck around for those appeals, right? But what I want to talk about more importantly is the humanity of our clients and what they're going through when we work with them. And I want to give you Sam's story because it is truly a horrifying one, and it is also one that kind of underpins these issues that we're talking about when we're talking about racial trauma and intersectional oppression, okay? So Sam, not only is he already a man who's being subject to detention for an almost non-existent criminal violation, but he happens to be a 6'3" Black man, and so he has that working against him. So while he's in detention, he receives the worst treatment. That's just a given, right? The detention guards are going to treat him as violent, even if he's calm, because he is large. He also makes the mistake of being a bit of a jailhouse lawyer and helps other people, researches their case, looks things up at the law library, and has always been spending all of his time at the law library. And the detention center doesn't like that very much because they don't like it when people know about their rights. And what happened, at least on one occasion, they decided to transfer Sam to a detention center in Alamance County in North Carolina for 6 days, just so that he could be beat up by guards and so that they could kneel on his neck and almost kill him, and they can cause permanent nerve damage in his thumb. Then he was transferred back to a detention center in Georgia after a few days. This man also had a heart aneurysm, and it's a pandemic, and we're trying to get him out of jail, and nobody wants to get him out of jail. And then what happens was that he gets sent to another detention center just for a day. The guards are messing with him, and they're telling him, oh, well, you know, you have your doctor's appointment, but we're going to stop at this other jail in this other county for you to have a restroom break. Now, Sam told him, well, this is an unauthorized stop. I'm not getting out of the van. And thank God he didn't, because that town was Forsyth, Georgia, which had a racial cleansing and did not have any Black residents for 75 years until the 1980s. And so I know for a fact if he would have gotten out of that van under those circumstances, he would have ended up physically harmed, and he would have ended up hurt again. Now, why do I tell you this very, very severe traumatic story? Is because so often, especially those of us who are immigration advocates, our clients are living through these intersections of trauma constantly. They're living through the trauma of detention. They're living through the trauma of poverty. They're living through the trauma of being of a darker skin, of speaking another language, of not having citizenship here. And all of that compounds on everything that they're going through. And then they come to us and ask us for help to try to help them stay here and get a work permit and have some stability and safety. And so all of that is just so important to understand for the context and for the history of our clients. And that's what we're trying to really kind of bring into the forefront, because we shouldn't think about trauma just as there was this one atrocious event that caused a thing. That is an antiquated understanding of trauma. Trauma is so much more complex than that, and trauma can come like cuts by 1,000 knives from all different angles, depending on what kind of life that you're forced to leave oftentimes. Next slide. Great. So now we'll jump into a bit of the trauma exposure response. And actually, before I continue, Mary, I just wanted to get a sense of where we're at with time.
Marla, you have plenty of time, so
Okay.
take your time.
Just wanted to make sure. Thank you. Okay, so we'll go to the next slide, please. Thank you. So when we're everything that we've talked about so far with regard to trauma is when you yourself are directly surviving a trauma that you are going through, right? Now, there's another type of trauma that can also occur that occurs when you are exposed to trauma, especially if it's over a prolonged period of time. And that's when we're talking about the trauma exposure response, which is referenced in this article here. And then I would also highly recommend the book called Trauma Stewardship. And if you look up trauma stewardship online on YouTube, there's a TED Talk that Laura Vanderneulipsky, I think I got her name right, gives, that is really, really fantastic. And when we're talking about the trauma exposure response, we're talking about that response that we have as trauma workers. So even if we ourselves have lived blissfully happy lives and just are exposed at trauma through our work, which I highly doubt is the case because trauma tends to attract trauma. But even if that were the case and we were just clean blank slates, just doing this work would cause a response in us that is very akin to being traumatized directly. And that's that trauma exposure response that we're talking about. And a lot of these symptoms can look very similar to surviving trauma yourself. And so Laura Vandernoot-Lipsky actually kind of goes through a whole bunch of kind of 16 different responses, and some of them are listed here. Now, a lot of these are probably going to look really, really, really familiar, but there's a couple of things that I kind of just want to settle on here for a second, okay? First, this overwhelmingness and all of these feelings. Now, what we have to understand is all of this put together means that when we are suffering a trauma exposure response, we actually are not using our brains in a way that will allow us to embrace complexity and nuance to make sure that we're able to provide the best strategies possible in our work and for our clients. And so it is, I say this because we have all had our moments where we're like, we can get through this and do this work. Nothing touches me. My morbid jokes at the end of the day are enough to melt everything away. That's not true. That's totally a lie. We're telling ourselves the reality is that this trauma exposure is affecting us. And it's just a matter of us really being able to understand what our coping mechanisms and what our windows of tolerance are for that exposure. The book was Trauma Stewardship by Laura Vandernoot-Lipsky. If you just look up Trauma Stewardship as the book, you'll find the book easily. And so that's really important. And you know, we're not in an ethics CLE right now, but I just want to really highlight that our failure to work within that window of tolerance, and by window of tolerance, I'm talking about, it's a term that's used in psychology, and it's about when we're in that state of being where we're most readily able to receive information, process, learn, be creative. Okay, we all know what that feels like, even if it's only a memory of when we might have felt like that once upon a time, but we all know what that feels like. And that's what we want to strive for, is we want to strive for our minds to always be within that tolerance, to our stress levels to be within that tolerance, so we can really be as creative for our clients as we possibly can be, right? Now, the other thing that's really important is, you know, if we have lost this ability to embrace complexity and nuance, and we're kind of like seeing everything through this haze because of our symptoms from the trauma exposure response, we're not going to necessarily know that we are right now feeling anger, irritable, tearfulness, numbness, despair, because of our trauma exposure response, right? We might be thinking of something else, like someone didn't do the dishes yet again, but maybe it wasn't the dishes, maybe it was the work coming out at home, right? So we need to be very mindful about that too. Now, the other thing that I really want to talk about is, what does it mean when we talk about the trauma exposure response within the context of privilege, right? Now, one thing that I want to be very clear about, and I say this as someone who is a trauma survivor, I have CPTSD, and it is something that I struggle with every day and I have to live with. And I am also a trauma survivor. There's a lot that I have in common with a lot of the clients that I've had and that we all have. And what's really important to understand is that, I'm sorry, my brain just blipped a little bit because of my PTSD. It causes dissociation, and so I have brain farts on occasion. So what I was trying to say is that I consider myself a directly impacted person in the work that I do because of the relationship that I have to migration and the relationship I have to trauma. And even being a directly impacted person, I want to be very, very clear in acknowledging the power that I have as someone who is a US citizen, who is fluent in English, who is someone with a law degree, who actually knows how to navigate the legal and social systems of the US. And that is a huge, 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 huge privilege. And the reason why it's so important to recognize that is because that necessarily contributes to a potential power imbalance that we're going to have with our clients, right? And so when our clients are going through a lot, we're going to have a trauma exposure response that's going to be so mirrored to what they're going through as well, right? So we can have over-identification with their trauma and think that, oh, I'm so woke and the best ally, I know their pain. And no, we don't. None of us know anyone else's pain and what they're going through. And the problem is that as lawyers, we don't get the same training that social workers and psychologists get on how to maintain that professional distance within trauma with our clients, right? And so while it's very, very important, and we'll talk about later about what it means to kind of connect with your clients, it's also very, very, very important to have kind of that very strong sense of self and your own understanding of your boundaries of yourself, in order to make sure you're not over-identifying with your client's trauma, because that is when we can make the mistake also of contributing to our client's trauma. One example that I can give is I do a lot of trainings on trauma-informed and anti-racist lawyering. And one of the things that I always tell lawyers to watch out for is, you know, as you're reading and learning about anti-racism and Black history, and I'm seeing a lot of attorneys who are getting very excited about what they're learning and feeling empowered about that. And I think that's wonderful. But then sometimes they take those conversations to their clients in a way that can be very harmful to their clients, right? And so, for example, I frequently say it's very important to develop these kind of open and vulnerable and authentic relationships with your clients, but it's a controlled professional vulnerability, not an open faucet of emotion, right? And it still creates the distance that we need to be able to fill our roles and do our jobs and work with each other well. And frequently what I see happening is that sometimes lawyers get a little overexcited about knowing these new words and these new things about trauma and anti-racism, and they then kind of overburden their clients with that, right? I mean, like, oh, did you see the news? I'm so sad about this. And it's like, but is that for you to burden your client with when your client is the one who is traumatized in this situation and asking you for help? You always have to make sure that your client is the one who is centered, and not you and not your feelings and not even your intent. Should always be the impact on your client that is centered. There's one other thing that I wanted to mention here for a second before we move on to the next slide. But I guess I also just wanted to pause for a second because I feel like we do have quite a bit of time, if I'm not mistaken, to see if there might be any questions either from the audience or even from other panelists that can help move us along as well. Let's see, there's something in the chat. Okay, so here we have something in the chat that I'll read out for folks to read. It says, thank you, Lorelei, for the story of Sam. Are there cameras inside the prison trucks and a vehicle tracker to ensure the safety of prisoners? And if not, then how difficult is it to defend his claim that they stopped at the town? If he was already suffering from trauma, then the extra hurdle he would have to overcome to prove his detention claim surely adds stress and further trauma, and as such, detainees should be offered extra protection so not to keep adding extra layers of trauma. Thank you so much for this comment. What I would love to do right now is maybe just take a moment to distinguish between a few things that we're talking about. These questions come from a place of a very, very good intent. And I think what we want to focus on too, though, is not just the legal claims. We're not talking about the legal claims here, right? We're not in a training about what the legal claims are going to be, but instead, what does the trauma mean for your relationship with your client and how you work with each other, right? And so whether or not there were, you know, cameras or a tracker or anything like that, honestly, it's Georgia and it's detention in Georgia. None of that really matters because there's almost no legal claims anyways, because the laws are beyond horrible. And so that's why we also have to make sure that we keep our focus on the humanity of our clients and their lived experiences, because ultimately at the end of the day, our work needs to reflect at least no extra harm done by us onto our clients. And we'll go through kind of like some hypos later also to kind of show that as well. Let's see, we have another question about how to navigate conversations with some clients who maybe haven't grown up with the kind of same systemic racism dynamics here in the US. So this is a really great question and a really important one. And Mary, please nudge me if it's time for us to move forward on anything. So one thing that I think is really important to understand is that racism and colorism is not unique to the US, and it is very, very similar in other countries. I am trying to think, for example, I've lived in many countries, and when you think of like the Dalit in India, when you think of housekeepers or jeepney drivers in the Philippines, when you think of the Garifuna in Honduras, colonialism has reached every single corner of this world, and so therefore racism has as well. Now, I will say that the US has a very uniquely complex, I think, political and social way of digesting race, with a certain lack of accountability and lack of transparency that is a bit, what is the awful word for awe-inspiring? It's like the really, really bad version of that. So I think a lot of these conversations are actually not new or confusing to my clients. And so when I have had to have conversations with clients, I'm thinking, in particular, I just remember having to do so many family petitions that were very similar. It was all newlyweds with new babies, but it was like a couple of Black families and then one white family. White family got approved, no problem, no NOID, no RFE, no nothing. All of my Black clients had interviews upon interviews, RFEs upon RFEs, and most of them hadn't, been born or raised in the US. Even the principals who were the petitioners were migrants as well, and they knew better than I did, the racial consequences of what it meant to submit this application and what those delays look like. And so, and I think also, one thing to remember too is that these conversations are important within the context of the work that you're doing. And so it's up to you to also explain that context. So to give you an example, when I was doing habeas litigation over the summer in Georgia, it was so frustrating for my clients because they were like, well, when are we going to get out? When's the judge going to decide this? And we did the inspection. Why isn't he like doing something? Because they're not social distancing or testing or even giving us cleaning supplies. I mean, the conditions were truly and still are truly, truly, truly awful. And I have never been so gaslighted by a judge in court before in my life. And I had it was an important and actually helpful conversation with my clients to tell them like, hey, listen, this is the history of Georgia. This is the history of the South. This is the history of our court system here. This is why things are unfair. This is why only the words of the white wardens matter, whereas the words of dozens of immigrants of color doesn't, right? And they know this more than we do, 1,000%, 1,000%. Great, another question about how to create professional distance with those skills. I think that this training, perhaps we'll go through a little bit of that later on. And then afterwards, if we have any additional resources, we can share some of that. Bias, you are not sensing bias in me against the southern states of the US. You are sensing PTSD because I have truly been traumatized and gaslit by courts in the South. So that is the bias that you are hearing right now. Recommendations or techniques about how to keep the client centered in the moment when we are feeling trauma ourselves. I think we'll probably touch on that a bit later on as well. But I think, for me, I think that the strongest thing that I can say that is the most helpful thing in a very real talk way about that is, is having therapy and mental health services myself. That by far is the thing that helps me to stay grounded when I am dealing with clients who maybe have the most difficult stories for me to hear. And so knowing that I have a therapist and mental health services, that is what keeps me grounded and stabilized when it gets really difficult. I'm not entirely sure that, you know, it would be very easy or possible for anyone to do it in a healthy way without some professional support. At least I haven't heard of that. And I will say that one of the things that social workers or clinicians and therapists do is they do also make sure to also go to therapy as well to process what they're working on. Great. Okay, cool. So we have pause and questions. So maybe we'll move on to the next slide, which I think is the last from mine. Okay, so here we're talking a little bit about the self-care. And so I actually personally do not like the word self-care, if only because I think that there is an important need to understand that it should not be self-care, it should really be community care. And there are some things that we can do ourselves to take care of ourselves, but we also have to make sure that we provide enough space to recognize the moral injury that doing this work causes us, right? And when I talk about moral injury was really coined for war veterans and that specific type of PTSD survival. And it was described to, it was used to describe how soldiers felt when they joined the military with a very strong desire to support their country and defend their country and do good in the world. You know, I grew up as an Army brat. I know how strong that desire can be. And then when you actually go abroad and engage in the work, you're actually causing harm or contributing to harm, or other things are happening. And it's not what you thought it was going to be. And so that kind of disconnect is what they call moral injury, and it has some very real kind of mental health and physical side effects because we also somatize so much of this trauma in our bodies. And so because of that, I think it's so important to create communities of care and making sure that you have support in your personal life and your work life. For me, because of the nature of the work that I do, I tend to do some of the most traumatic work, you know, unaccompanied minors, detained families, and just kind of really get into it, spend a lot of time on the border. And so I personally feel like I need to have a lot of friends that I can diffuse my vents to, because I think it would be really hard on my couple of, you know, one or two best friends to hear all of these vents, right? And so when you're talking about having communities of care, it's like, who are you talking to? A lot of people use Facebook groups of other immigration attorneys. I have texting groups with other immigration attorneys where sometimes we're just writing and just letting each other know, like, yep, I'm working on my writing, or I'm working on my art, I'm doing something that's just for me. So that way there's a buddy system in play. And that to me is like the most critical part, right? And once you have, and as you have that community, you can be doing things on your own as well. And whether it be taking breaks or ensuring balance or making sure that you're relaxing or maintaining your health. But I think that the other thing that is so critical for being able to engage in kind of real personal care in this work is having top-notch organizational skills. And if you're working at a nonprofit, for example, and you're a manager, having grants management skills, just having those organizational skills are just so critical, because you know the way I've been able to survive the work has frequently been able to, what's the way that I can kill as many birds with one stone as possible, optimize my work as much as possible, so that way I can protect the brain space that I need for kind of complex work, right? And so it has to be kind of almost like a strategic resource allocation of brain space, right? It can't just be work, because even if some of us can handle that for a bit, eventually we all burn out. Okay. Great. And I think that's it for me. Any other questions right now?
Lorelai, actually, On my next slide is our break and our first CLE code, but I realized that the code that I used didn't actually come up while you were talking. You almost always use this term, so I was hoping you would give us a minute to talk about race equity.
Yes, absolutely. I apologize. It's usually somewhere in my slides. I've been going through some very interesting PTSD healing lately, so my brain's all over the place. But so for race equity, one of the things that I really think is important in thinking about our work is thinking about whatever choices we do have, what choices do we have to achieve a little bit more equity. And so, for example, if you're a manager at a nonprofit, have you spent time thinking about your case selection process to make sure that that's equitable to all of the communities that you're set out to serve, right? Have you thought about the legal arguments that you can bring that are race-based, right? So, for example, I mean, so many immigration laws can still be challenged on equal protection grounds. I'm thinking, the easy hanging fruit is the naturalization or citizenship cases that people are always watching out for to see if they can challenge it again. So there's a lot that can be done for race equity, and I would encourage folks, if you have desires to learn even more about race equity in particular, I'd highly recommend the Racial Justice Institute with the Shriver Center. It's a 6-month, 7-month fellowship kind of workshop type of thing that you do while working, and you work on a race equity project.
Thank you, Lorelei. And everybody's asking about the code because I mentioned it. I promise it's coming up on the next slide. I just wanted Lorelei to at least explain the words so that everyone had the background. I like to choose my CLE code strategically. If anybody has any questions for Lorelei before we go to our break, feel free to put them in the chat. Someone asked the Race Equity Fellowship, if you could repeat the name of that, Lorelei.
Yes, it is the Racial Justice Institute with the Shriver Center, and I'll put it in the chat as well.
I also briefly in the chat mentioned a YouTube video that I like. It is in the healthcare context, but it does help to explain the concept of moral injury very well. It's called It's Not Burnout, It's Moral Injury by Dr. Z. Again, it's in the healthcare setting, but you can look it up, and I think that you can see how it can apply to the legal setting as well. And it's just a good explanation of, again, moral injury in that term that Lorelei was using. All right, so if we have no more questions right now, I will put up the CLE code. I know everybody was anxious for it. And, oh, actually I got Lorelei. So let's see, I have a comment or question here. It's difficult for a lawyer to rewire their way of thinking from what I can legally do to protect my client to more thinking that I need to stop and think of how I can address the client's trauma from their personal level and not from a legal vantage point. So thank you for that distinction in your answer to my question. I will bear that in mind and work more on developing those skills with clients alongside the legal skills I'm learning in practice. And to this commenter, I have that same problem. And unfortunately, as a lawyer, you do have to learn to distinguish that there's only so much that we can do for them as a lawyer. And we're going to talk soon about setting clear boundaries and roles and limitations with your clients on what you can and cannot do with them. And I would say that you should do that to yourself too. I know that personally in my practice, I had to tell myself, I'm not their caseworker, I'm their lawyer, because if I become their caseworker and their lawyer, I get overwhelmed. I can't help as many people. I can, taking on less cases. And so in terms of working at a civil legal service agency, obviously, I want to be able to represent more clients because there are caseworkers elsewhere. There are other people who can help with these things. And you need to be able to set your limitations and boundaries and help them with the things that you have the skills, the expertise, and the knowledge to do. And in fact, helping them with other things could actually be more harmful because I'm not a counselor. I'm not a caseworker. I don't have the skills and knowledge to do those things for my clients. And I could end up doing more damage than good. All right.
I would also just add real quick that I think that there's an important distinction here because this first part of the CLE, we're talking about trauma, but we haven't yet talked about what to do with that information, right? And what we're not saying, and you will never hear me say, is I'm not asking anyone to be anyone's therapist or to cross any boundaries or anything like that too. And so, and I say that because I know that there's already probably some people who are thinking like, oh, what are these lawyers telling us to do? No, we're not doing that. But the reason why we're spending so much time talking about trauma is because you need that context when your client walks in that door. If your client is quote unquote being a difficult client, but it's actually PTSD symptoms and not them being a difficult client, that's going to change how you interact with them. And we're going to talk about that in a minute as well. And we're also not talking about you needing to be the answer to all of your clients' problems. But if you actually know what your client's life looks like in their real world, then the solutions that you'll be able to craft for them within your area of expertise are going to be that much more powerful and targeted, because they're actually reflecting what they need as opposed to what you think they need when you're not the one who lives their life, right? And I'm thinking, generally you, not any you in specific.
There's another comment / question that's popped up talking about, which I think is an excellent question, and I hope there are many executive directors of organizations or other leaders, managers in organizations here. The commenter is interested in the context of vicarious trauma when the employer's response is not support or self-care. It's, if you're an immigration attorney with a high caseload, or any attorney with a high caseload, pressure to take more cases, right? And that's a very difficult situation to be in. And unfortunately, as the employee, it's very difficult to do much about that, right? So I hope that, again, we have some managers, some executive directors, et cetera, here who can understand that there is only so much of this work that you can do. You cannot have extremely high caseloads, even though I know that I feel it. I want to have high caseloads because I want to help everyone that comes into our door. But I also have learned that I can't do that because I can't be an effective advocate for my clients that I do have if I take on all these extra cases. Lorelai, any extra?
Yeah, I would also just say that be honest with yourself if your work is causing health issues for you. It is so hard for us to admit, I think, hey, I have increased anxiety, I have increased depression, I have PTSD maybe, because I bet you there's a lot of people in this room right now who have PTSD from our work as well, because you can get PTSD vicariously as well. The DSM had been modified for that, I believe. And so it's really important, because if that is the case, the ADA exists for a reason. Accommodations can be asked for in the workplace. Do they have any idea what accommodations to give you or how to give them to you? Absolutely not. But if we don't start asking for accommodations now, and if we don't start those conversations now, then the next generation of advocates who fall into our shoes after us are going to be that much worse off, right? We need to be brave and talk about our needs and ask for help. And I know that's a really, really hard thing to do, because I have had to do that and ask for accommodations for my PTSD in the workplace. And it was one of the most difficult things I've ever done.
Right, so someone wondering if other public service attorneys working so closely with clients are finding that during the pandemic, where we are already forced to isolate, that the type of work we do results in wanting a lot more alone time when we have time off. So it sounds like she's looking for lots of feedback. So any public service attorneys who want to put in the chat their response to this, that's great. But if any of our panelists have responses, that you can go ahead and.
I will just say yes. Yes, I have needed more alone time to decompress.
All right. I'm going to show our code one more time and just announce it. It's race equity. Again, that was something that was discussed momentarily ago. So the first CLE code, race equity. When you write it in your form, you can put it as 2 separate words. You can put it with a hyphen in between. You can make it 1 word. People always ask me this, so I figured I'd announce that and get it out of the way. Race equity. And we will take a 10-minute break and then come back to talk about the trauma-informed stance and how to work through our clients' trauma to build strong attorney-client relationships with them. So I will see you all at 5:06. Everyone. I hope you had a good 10-minute break and got up and stretched. I personally went and stood in my front yard in the sunshine and did some stretching. My neighbors looked at me a little weird. They were like, "Why are you in your front yard stretching?" And in my head, I responded back to them, because my backyard doesn't have any sunshine right now. It's the wrong time of day. So anyways, I hope everyone got to get up, stretch, get a little bit of the sunshine in, maybe whatever fills you back up, so that we can dig in. We're going to continue on and talk about what's called the trauma-informed stance. And this is where we're really going to start digging in and talking about how to work with clients who have had trauma. We've talked about what is trauma and the effects that it can have, but we're going to start by talking about the specific effects that it can have on the attorney-client relationship, and then how can we work through this trauma to continue to build a good, solid attorney-client relationship. Okay. All right, just modifying my screen. Ready to go. Okay, so obviously the goal is to build a good attorney-client relationship. So let's talk about what that includes. First of all, we should all be striving for a client-centered relationship when we are building our attorney-client relationships, right? And a client-centered relationship is where we put the needs and the desires of our client first, okay? So the client is the one who runs their representation. They have hired us, whether or not they are paying us if we are public interest attorneys, and we give them the legal information, and we discuss the pros and cons of the various decisions that they can make regarding our representation of them. But ultimately, they are the one who decides the course of their representation, okay? So again, before we get started into building a good attorney-client relationship through trauma, let's talk about building this attorney-client relationship, this client-centered relationship. Obviously, we need to build a trusting relationship where we trust the client and the client trusts us. We need to communicate effectively with the client, and we'll talk about what effectively means. We need to listen to the client. If they're the ones that are guiding the representation, we have to listen to their goals and what they want. We explain the law to a client in a way that is understandable to them, and sometimes that's going to look different based on trauma. We allow the client to lead the representation, and we'll talk about ways that you may be leading the representation even without realizing that you are, and how you can step back and make sure that the client is leading the representation. And you always make sure that you're prepared. You know the law, you develop a legal strategy based on the client's goals, okay? So while building this effective client-centered relationship is good for all attorney-client relationships, there are a variety of factors that affect how we build this relationship. So we have the what we want, but how do we get to that what? And you can see here that I've listed numerous things that can affect the dynamics of a good attorney-client relationship. The very last one is trauma. So you can see that there are many things that can affect the attorney-client relationship, and trauma is just one of them. And we're going to be focusing on trauma, but we do have to recognize that intersectionality dictates that for every client, there's going to be more than one factor that influences our relationship with them. And so developing a good client-centered relationship will be a different process for every single client, okay? So again, today we're focusing on trauma and its effect on our relationships, but always consider all the factors that are going to influence your relationship and act accordingly as you work to develop your attorney-client relationship. So let's take a few minutes to talk about how trauma can affect the attorney-client relationship specifically. Again, we've talked about trauma's impact generally on a person, but how do those impacts impact the attorney-client relationship? Trauma, first of all, significantly impacts an individual's ability to trust others. Their trust has often been violated in the past by those who have inflicted trauma upon them, and these past experiences will make it difficult for the client to trust you as their attorney. As an attorney, depending on the information that we need from our clients for effective representation, depending on the matter that we're representing them in, we're often asking our clients to tell us incredibly personal information that they normally would either share with only their closest friends and families, or maybe even no one, right? But yet we're asking them to divulge this sensitive information to a relative stranger. So we just have to understand that there's going to need to be time building trust, and we're going to talk about tactics to help build trust with our clients. There's also going to be communication barriers with our clients. Kayla talked about, how trauma literally affects the brain and the neurology of the brain. And this means that a client may not be able to tell their story chronologically. They may not be able to tell appropriate details. Sometimes that's because they don't remember certain details. They remember the things that triggered their trauma more, but less of the kind of, what we see the leading up to or the side events. There also is a possibility that they could be re-traumatized while we are gathering their story, right? So Kayla talked about triggering hyperarousal and disassociation. What happens when you're trying to get this information from your client that you need to be able to represent them? I often say that as a lawyer, we have to necessarily re-traumatize our clients, and I despise it. But nonetheless, that is what we have to do in the legal system that we work in, depending on the legal matter that we're representing them in. We have to gather their story, but what happens when gathering their story triggers them or leads to hyperarousal or disassociation? But also, how can we do our best to limit the amount of triggering, right? And again, we'll talk about that. And finally, clients may avoid you altogether because of all the reasons that I've been talking about. We're asking for this sensitive information. They don't want to share this information with us. They don't trust us. They don't have a close relationship with us. They know that they might be re-traumatized while telling their story to us. And so they may avoid us altogether. And that's very difficult because obviously you need to communicate with your client and get information from your client to be able to effectively represent them. But they may be trying to avoid their re-trauma. It's not that they're avoiding you. It comes out that way. It seems like they're avoiding you, but they're avoiding being re-traumatized and having to deal with the effects of being re-traumatized. And so obviously that can create a communication barrier. Clients also may experience diminished information processing. So when we attempt to explain what is often already a very complicated legal landscape and their options in this landscape and the pros and cons of each of these options, they may have difficulty retaining this information or even truly understanding and comprehending what their options are. And so we have to understand that again, this is a literal result of trauma. It changes the brain. It makes it to where they have difficulty processing and retaining this information. And so we'll talk about some tactics to, again, overcome that. And then finally, and relatedly, clients may have impaired decision-making ability. They may not understand the options presented to them, as I mentioned. They may feel that they can't trust their instincts on what's best for them because, things that have happened in the past, their decision-making hasn't led to necessarily, in their opinion, it has led to potentially their trauma, their decision-making, even if that's not true. And so they may not think that they even have the ability to choose what is best for them. So clearly, trauma affects several incredibly important aspects of building a client-centered attorney-client relationship. And so let's talk about how to work through this and using trauma-informed lawyering. So trauma-informed lawyering is, how can we put this? Trauma-informed lawyering recognizes how trauma affects the attorney-client relationship. But it's not a formulaic approach. I can't tell you do X, Y, and Z, and now you're a trauma-informed lawyer. Instead, trauma-informed lawyering is a philosophical framework. It's a different way of thinking about your client and your relationship with your client. We're realigning our view from thinking, what is wrong with this client, to what happened to this client, okay? So again, we're just changing the way that we're thinking about situations often. So trauma-informed lawyering has two primary goals. We want to create an inclusive, welcoming, and destigmatizing environment by practicing empathy and non-judgment so that we can build trust with our clients. And we want to ensure that we restore control to the client. So many traumas take away control from clients, from individuals, and we want to restore that control by ensuring that the client understands their legal proceedings and then empowering the client to make their decisions, including those that may emphasize their safety as opposed to what we think is the best outcome legally. Okay. So there are three components to this. How do we effectuate these goals? Through three components. We first have to put the reality of the client's traumas first. It's at the forefront of our interactions with the client. This allows for the attorney to empathize with the client and understand their behavior and responses. We also have to adjust our practice approach based on the client's traumatic experience. And we'll talk about this as the trauma-informed stance. And then we also have to adapt litigation strategies that empower the client to take into account their physical and emotional well-being and making decisions on their case. So again, to us, this may look like they're making a bad decision for their case. It might not be the best legal outcome, but based on their trauma and to emphasize their safety and their security, it may be what is best for them in their lives. Okay. So importantly, a trauma-informed practice also encompasses the practitioner employing modes of self-care, or hopefully an organization employing methods of organizational care to counterbalance the effect that being exposed to others' traumatic experiences may have on the practitioner. And so Lorelei has spoken about this, and I just want to re-emphasize that we're going to talk a lot about what we can do in our interactions with the client, but when we're not interacting with the client outside of our workspace, we need to make sure to engage in this self-care. So in adjusting our relationship and adapting our litigation strategy, we are going to utilize what's called the trauma-informed stance. And you see here that there are 5 practices. These 5 practices help us to build trust, increase feelings of safety in our clients, minimize their feelings of powerlessness, and even promote feelings of empowerment so that they feel like they have control over their situation. So let's go through these one by one. The first practice, and it's an incredibly important practice in trauma-informed lawyering, is transparency. Transparency is critical to gaining a client's trust. If they feel that you're hiding the ball from them or not telling them relevant information, they will not trust you. Transparency is also critical to helping a client feel safe and in control of their own case. So transparency includes expressing clearly and fully the client's legal case and their options. You don't want to sugarcoat anything. You don't want to indicate that a likelihood of success is higher than it actually is. You want to realistically inform your client about their case, okay? And the client is the decision maker. Your role as the attorney is to advise and inform. You have the legal knowledge. You impart that legal knowledge to your client in a way that they can understand, and then they make the decisions, okay? So a few tactics that I have here to promote transparency is explain your actions, all of your actions when you're working with a client. And one action that I have here is note-taking, okay? So when you're in a client meeting with someone, whether it's via Zoom or in person, and you're sitting and you're looking at your notepad and you're writing things down, the client wants to know what's going on. They might think that you're writing, this client is crazy and I don't understand why they are acting in this way or what they want me to do, okay? So if you explain your note-taking process and the purpose of your note-taking, that can help to relieve the client and to help them to trust you. So if you're taking notes on their story so that you can write an affidavit or another document to submit to a court, say, I'm taking notes about what you're telling me right now about your story so that I can accurately convey this information to the court at a later time, okay? If you're taking notes about that, like if they're talking about what they want out of the litigation, say I'm taking notes so that when I research the legal landscape later, I can keep in mind your goals and what you want out of my representation of you, okay? So that's an example of explaining your actions. It can be even as small as explaining why you're taking notes, okay? It's also important to explain why you may be asking them for certain information. So again, my example here is details about a traumatic event. If you're having to ask a client to relive their trauma and give you details about what happened, you know, from start to finish, which, you know, I work a lot in immigration and family court, and unfortunately, a lot of times these entities want a lot of information about what happened in order to be able to make their decisions. You want to tell your client that. You want to explain to them that you're trying to make sure that you meet the legal standard that's applicable. You're trying to prove what you need to prove to get them the relief that they are requesting. And again, put it back to their goals. I also find that putting the legal entity under the bus is helpful. So, you know, I don't want to have to ask you these questions. And that's true for me. I don't want my clients to have to relive their trauma by telling me about it. But I know that it's necessary because that's what I have to do to prove their legal case and to get them the relief that they're seeking. And so I say, you know, if it were up to me, I wouldn't make you relive this. But as your attorney, I have to make sure that I can adequately explain what happened to you so that you can get the relief that you're asking for. You also do not want to hide information from your client unless it is absolutely necessary. And in fact, I couldn't think of any times where it was absolutely necessary for you to hide information from a client permanently. I can think of some informations where it might be necessary to hide information from a client temporarily. So for example, if you get bad news about something related to, a client that you're working on, and you're about to go into a court proceeding, and the bad news that you received is not going to come up in this court proceeding, this particular court proceeding. So for me, I represent people in immigration and family court a lot. So maybe I'm about to go into a family court appearance, but I got some bad news about their immigration case, and that's not going to arise in their family court case. I might not tell my client that right before we're about to walk into the courtroom because I don't want them to be re-traumatized and being triggered and experiencing all the negative effects while we're in the courtroom. That doesn't mean I'm not going to tell them eventually, obviously, but like I said, do not hide information from your client unless it's absolutely necessary. Because again, if you hide the ball from them, they're going to think that you're hiding things from them because you don't trust them, because you don't think they can handle it, because you're trying to scheme against them. Maybe you're on the side of their abuser or whoever has caused their trauma, things like that. You also, this is what we were talking about briefly earlier, you need to explain your role as an attorney and your limitations as an attorney. You need to tell clients what services you do and do not provide. Okay, so again, this can be, I am representing you in legal matters and I can't do things that may be more case management type, like helping you apply for health insurance or things like that. And just being clear on that so that your clients don't feel like you're shutting them down for no reason is important. This also, of course, can be limiting what your representation is for. Obviously, as a lawyer, we don't have expertise in every legal area. And so we can say, listen, I'm representing you in family court, in your family court proceedings, in an order of protection, and in your immigration case in seeking a self-petition under the Violence Against Women Act. I do not guarantee that I will represent you in any other legal matters. Okay, so again, setting those boundaries, what services you are and are not providing to them. You need to know what you can and cannot accomplish for the client. When they're telling you their goals, if they are not things that can be achieved through the legal system, you need to be clear about that with them. Many people who have been traumatized by an individual, what they want is that person to feel remorse. They want that person to say, I'm sorry. That is not something that we can achieve through the legal system, as much as I wish we could. And so you need to be clear about telling your clients what you can and cannot accomplish for them in their case. You also need to be clear with your client that their role is the decision maker. Again, this is giving them that empowerment, and then they trust you because they know that you are trusting them to make the decisions on their case, right? And so you make sure to let them know that your role is to effectuate their decisions, to give them information so that they can make the best decisions possible, but they are the decision maker in their representation. All right, so next we have predictability and reliability. This is the second key to the trauma-informed stance. Okay, as we discussed earlier, unpredictability can be a trauma trigger for survivors. So helping clients know what to expect can help to avoid that triggering. So look, we're already talking about avoiding triggering. We know that it can happen. Let's try to prevent it to the extent that we can. Being reliable as an attorney helps to avoid unpredictability. Your client needs to know what they can expect from you as an attorney. Maximizing predictability in an inherently unpredictable process, though, can be quite difficult, right? The legal process is almost always inherently unpredictable. We cannot predict the outcome of a case. But the important thing is to give as much predictability as we reasonably can, right? So even little things like explaining where each party is going to sit in a courtroom can be really helpful. And explaining as many possible outcomes as you can predict, but being clear that the outcome may be one that you cannot predict. That's reliability in and of itself, okay? You may want to role play where it's helpful. Like, again, I almost always practice with my clients before even little things like raising your right hand to swear to tell the truth. I mean, these are things that, again, it just gives them some reliability. They know what to expect when they're going into the courtroom, okay? So another thing about role playing, though, is that later we are going to talk about avoiding triggers in your questioning of clients specifically, but clients do need to be prepared for opposing counsel's or judges' questioning, which is likely to be triggering. And so role playing often can help give some predictability about what may happen in a courtroom. And even though you may be triggering your client, you'll be doing it in a safer environment and to prepare and give some predictability to what may happen in the courtroom. Okay. So what are some other things that you can do to be predictable and reliable? Again, Define your role. I said that. You need to define your role so that your client knows what to predict from you. If they know what you can and cannot do from them, if they know what services you can and cannot provide for them, that is predictable for them. They can predict what your answer may be when they come to you and say, can you help me with this? And you can say, no, unfortunately, that's outside of my area of expertise, or that's outside of the role that I can play for you right now. Okay. You also want to give reliable information about your schedule, your availability, and your means of contact. One thing that we always, or at least some of us, want to do is say, I'm available for you whenever you need me. And that is not good self-care. And so you cannot say that to clients, because inevitably they will call you at 9 o'clock or 10 o'clock or some other time at night, and you won't want to answer. You shouldn't answer, especially if it's not an emergency. Well, if it's an emergency, it might be something where you should answer, but nonetheless, you want to make sure to give reliable information about how your client can contact you. And so saying something to the effect of, I work Monday through Friday, generally from 9 to 5. If you call me, I try to answer. If I'm unavailable, leave a message and I'll get back to you within 48 hours, or really as soon as possible, but no more than 48 hours. If it's an emergency, I'll try to get back to you after hours or on the weekends. Okay, so that's still giving them access to you, but also understanding that you're not available at the drop of a hat, because we're in court, we have other clients that we're dealing with, we have lives, we need to engage in our self-care, we need to understand that our clients need to understand that they can't get to us at all times, okay? You also want to repeatedly preview what's to come in their case, okay? And so this can be talking about what topics are going to be covered in meetings, okay? So when you call your client up to set a meeting, don't just say, hey, are you available this Friday at 3? Okay, great, see you then. Let them know what you're going to be talking about in that meeting. Tell them that you're going to be talking about their story, or that you're going to be talking about their upcoming court appearance, and you're going to be preparing for that, and they may be triggered by some of your questions. That really helps them, again, to predict what's going to happen when they come to your office. Make sure to repeatedly preview possible legal outcomes. And I'm going to say repeatedly, because I want to make sure that we as lawyers, sometimes we think that we tell our clients once and they remember, but our clients may have information processing difficulties. We're already talking about very complex things that's hard for people who haven't experienced trauma to remember. So make sure to repeat the possible legal outcomes. Don't think that if you've told them once, that's enough, okay? Repeatedly tell them what decisions they're going to need to make in their case, okay? Again, this helps to give them the time to think through things and the predictability of when you're going to ask them. So if you have a month before they need to make a decision, make sure to tell them you will need to make a decision on your case. It doesn't have to be today, but you will need to do that for me by April 24th, right? Okay. Another thing that you can do to be predictable is to establish routines for your meetings. And this doesn't have to be anything crazy, right? What I usually do is, I have the office come into the office, or the client come into the office, I engage in a little chit chat, ask them about things maybe that we've talked about before. I talk about what we talked about in the last meeting to review what we've already talked about. And then I talk about what we are going to talk about in today's meeting. Then I give them a chance to ask me any questions or bring up anything that's concerning them. We'll talk in a few minutes about how if a client is thinking about something else, especially if it's triggering their trauma reflexes, they're not going to be able to focus on what you are trying to get from them that day. So you need to give them that time to ask their questions and to air their grievances or talk about what they want to do. Then I go over what I said that we would go over in the meeting. And then I kind of recap what we went over and what we'll be doing in the next meeting if I can plan that far in advance, okay? Or at least what the next steps will be. Even if I don't know what's going to happen or when it's going to happen, I say, this is our next step. We're waiting on X. You will hear from me as soon as X occurs, okay? You also want to follow through on your responsibilities, your commitments, and your appointments. And this can be hard for attorneys. We get very busy, especially if we are overloaded with cases. So don't do that. That will help you with this one, is to be able to follow through on your responsibilities, commitments, and appointments. Don't overload yourself with cases. But make sure that you can follow through on your responsibilities, commitments, and appointments, okay? Return phone calls promptly. Again, 48 hours is fine, especially if you've told your clients that that's the return time. Provide regular case updates. And I say this because sometimes, and I fall into this trap all the time, when I'm telling you things that are traps that attorneys fall into, it's usually because I've fallen into it. Sometimes I'll get an update on a case that seems kind of minuscule, not that important, and I'll think, oh, the client doesn't really need to know this. Like, it's not that important. It doesn't really mean much for their actual case. But to the client, it can mean a lot. And really, it's just knowing that you're going to call them. It's, again, that predictability and reliability that you're going to call them anytime something happens in their case. So call your clients and give them regular case updates. If nothing has happened in their case, call them and tell them that too. You don't have to do it every day or anything, but if you said, you know, it's going to be about 6 months before anything happens, and 6 months has gone by and you haven't gotten anything, call them and tell them that you haven't gotten anything, okay? And then avoid canceling or changing your appointments at the last minute. Again, I know this can be hard, but again, you can do this, you can think ahead. If you have a morning court appearance, try not to schedule something with a client that's shortly after that court appearance, because we all know that court appearances last longer than they're supposed to, okay? So look at your schedule closely when you're making that schedule, when you're making those appointments. And finally, do not make promises that you may not be able to keep. Do not tell your client that you will get a certain legal outcome in their case. Do not tell your client that anything is for sure going to happen in a court appearance. We know that things are too unpredictable for that to happen. And if you make a promise that you don't keep, that takes away from your reliability to the client and can diminish their trust in you.
Mary, if I can also add one thing that I think is really important for all of this, I think you laid it out in such a great way. But one thing that I want to highlight for people is the power imbalance that comes with attorney versus client. Because we're not just talking about trauma survivors, we're also talking about a very strong power imbalance. And the reason why I say that is because I can't tell you how many times like my clients are like, whatever you think is best, whatever you think is best, whatever you think is best. That's their trauma coping mechanism, because when you're used to being a trauma survivor, your instinct is to appease the person with the power. And many times trauma survivors, we do this without even realizing that we're doing it. You know, I find myself doing it all the time, even with the power of a law degree, right? And so just be cognizant of that. Do not be patronizing to your clients or paternalistic, but make sure that you're very warm and inviting when you are, following through, creating your routines, discussing this feedback with them. And make sure that you're having this a very respectful two-way conversation, and that you're not being paternalistic about it.
Absolutely. Thank you, Lorelei, for that. That's really critical. And actually, I think I'll come back to that a little bit later, but if I don't, I'm glad that you came to it.
Mary, there's a question that's being asked about transparency. What are some ways to navigate being predictable and reliable when working with detained clients, and communication with the clients dependent on whether ICE will actually give you the right to make the legal calls?
I have some ideas on this.
I was about to say, Lorelei, take it away.
Yeah. So first, most detention centers, I was able to kind of get into a pattern where I can get a VTC scheduled within a few days. So there are some detention centers where the access is even more atrocious, but for the most part, it seems viable to be able to get a meeting with your client, whether it be by phone or by video, within a couple of days. It depends on the case that you're working and the nature of the client and all that. When I was doing habeas cases, which was like very, very rapid, people are expecting to get released, and like there's just a lot more kind of frenzied stress. I would regularly schedule meetings with my clients once a week, even if we didn't end up using the whole hour, even if I didn't even have a plan for the meeting. And what I found was that it was really helpful to make sure that their anxiety was taken care of and that they felt very involved. And also the nature of detained work from the advocate's perspective, it's some of the hardest work for any of us to do out there. It's very traumatizing. And so it was really helpful for me to have these regular meetings with my clients, because that way, if I ever forgot to give them an update, which I did all the time, I didn't forget as much if I had a regularly scheduled appointment, right? And I would strongly recommend doing that regularly scheduled thing as much as possible, even if it's not weekly. It could be once every 2 weeks. It could be once every 3 weeks, create alternatives for communication, explain what your limitations are to communication. So if, for example, like they need money on their account and your phone is not set up for free, like you can actually talk to the detention centers and see if they can get you on the attorney list. So that way your phone call, like their call to you, counts as an attorney call and is on a do not monitor list. And like sometimes it gets in the free minutes with the whole like pandemic kind of rules that they were coming up with. And then the other thing that I would suggest is, make sure that you're using all other alternative forms of communication that you have available to you. So whether that be, developing a relationship with someone at the detention center, like a guard who you're buddy with, who can give you like information that you need sometimes, or if you're able to get the detention center to send you faxes. I think that's still being done, if I'm not mistaken. It was one of the things that should have been litigated for access during the pandemic. And so that was one thing we did frequently. If we couldn't handle the volume of calls, we'll tell clients to like send us faxes, and that'll let us know to call them back. But there are just ways, like within the uncertainty and the unpredictability, you can talk about, hey, I'm going to try to call you X, Y, and Z day or once a week or whatever. You can talk about that unpredictability honestly with your client as well.
Again, sometimes just telling people that it's going to be unpredictable at least helps that to be predictable, as silly as that sounds. But coming from the attorney, then the client knows that they know that that's the system. Another little trick that I had was that, if for example, something arose during the 3 weeks between when I had a regularly scheduled call with a detained client, something came up and they wanted to reach out to me. It was harder for them to make a call to me, but easier for them to talk to their family when their family called in, if they had family. And so their family would just call me and let me know that the client wanted to talk to me, and then I would set up one of those meetings. It's easier for the attorney to call in for them than for the client to call out. All right.
We also had a question in the Q&A that I don't know if we were going to address now or later. The question is, can you talk about comparing traumas as a practitioner? My impression was that comparing what is more and most less traumatic is generally not condoned.
So we talked earlier about trauma, right? We talked about the 3 E's, the event, the experience, and now I'm forgetting the last E. If anybody can chime in for me, that'd be great. The effect. And so remember that a traumatic event in and of itself doesn't necessarily tell you what the effect and the experience the client will have will be. And so even if we look at an event and say this event should be less traumatizing than this event, again, that comparison, the experience and the effect on the client could actually be the same. And clients will react differently depending on what past trauma they have, different things about, personality wise. And so comparing traumas is always difficult, because if you compare traumas, it can come off as in this trauma is worse than this trauma, and so your trauma, I'm not respecting your trauma, I'm not respecting what happened to you, right? And so it can be very difficult. And we sometimes talk about things as like very traumatic experiences, but note that we're not saying that that another experience is not trauma or might not be as experienced as traumatic. We're just identifying situations where you can be particularly sure that a client may be experiencing trauma.
I'm not sure where the question was coming from necessarily, but I can imagine that another situation where I've seen advocates raise that question is when we're basically trying to sell our clients' trauma to CIS or EYR, and then in a sense that in and of itself is an exercise in comparing traumas and whatnot. And one thing that you can do, and this is something that I've seen clinicians do with their clients when they write affidavits in support of their patients, is talk very openly and honestly with your client about what you're putting in the declaration or the application and why. And I've done that so many times before, where frequently what I've seen, and this has been my experience with my clients and also my own personal experience, but oftentimes the things that are most traumatic to us as human beings are not the things that are physical in nature, the things that are more psychological and emotional in nature, but that is not visible enough for the kind of work that we do as, peddlers of trauma, as I think of immigration attorneys oftentimes. And so my clients frequently would fixate on like, but he called me this name, but he treated me this bad, or he did this or he did that. And I would just have an honest conversation with them and like, listen, I hear you. I agree. That's so messed up, but this is what we have to do to try to get you the visa, and this is how your case fits into that. And I think that if we focus on this incident, this incident, this incident, it'll convince the adjudicator to grant you your case, right? And another thing that we've kind of touched upon is, remember that, you know, our clients have told their stories over and over and over and over and over again, right? And so they already know that they have to sell their story, because they're selling their story to you, right? You don't see it as them selling their story to you, but they are selling their story to you, because when they're begging that you take their case, they're already engaging in that practice. And so when you have an honest conversation with them, it is not something that is unexpected for them. It's not something that is foreign for them. It's something that just goes right back into like their own pattern and practice, and they can say, yep, I get it. That makes sense. Like, yes, we got to sell my trauma, because that's unfortunately the world that we live in and the work that we do.
All right, so I'm going to move us right along. We're a little short on time, but I think we'll make it through. Our next trauma-informed stance practice is patience. Patience is key when working with trauma building. It is going to take time to build trust and rapport with your client, and you have to understand that. You can't expect that your client's going to come in for one meeting, you're going to get all the information that you need from them, and then you're going to be able to work on their case. It's going to take multiple meetings. It's going to take time. Sometimes you might not even talk about their legal issue in the way that you think that you should be talking about their legal issue. I understand that sometimes that there are time limits, but you have to build that into your representation of clients to the extent possible. Okay. So make sure that your client meetings have enough time to address client concerns and adequately discuss and explain their case options. Because again, you might think that you've already talked about these things. You might think that you're talking about X, Y, and Z in today's meeting, but they come in and they're worried about A, B, and C, and you need to make sure that you have time to address their concerns. Because if you have an agenda for the meeting and you want to just push forward into that, but the client is focusing on what's in their brain, potentially in the forefront of their mind, potentially providing some trauma triggering for them, the amygdala is going to take over, right? They can't understand the reasoning or the importance of what you find logically important to their case. And so you need to give time in these meetings to let the clients get those things out if you really want to be effective in getting the information that you know logically you need for their representation. Okay. Again, you're going to draw out sensitive information over multiple meetings so that this can be more manageable for clients. On occasion, I find that a client just wants to run through their entire story in one really long meeting, and maybe that's what's going to be best for them. Maybe they don't want to have to talk about it in multiple meetings, but most clients, it's going to be very difficult for them to sit and discuss their trauma for hours on end. But if they want to sit and talk about it, that's their choice, and you can't tell them that you think that they're being triggered or re-traumatized and stop them. They want to do, like, it's their choice in their representation. Okay. You want to give the client time to tell their story with minimal interruptions. So you're going to practice active listening. Tell the client the information that you're looking for, but then give them the opportunity to share their story with you instead of just responding to your consistent and specific questions, right? This is called the T-funnel method of questions, because you're starting with broad, open-ended questions, and then you're obtaining details later by asking the follow-up narrow questions. And this might even be in a later client meeting. It might not even be in that same day, because again, you want to have minimal interruptions to your client's story. You want to be comfortable or become comfortable with pauses and silence. If your client stops, don't jump in and take over during these times. Stay patient and allow the client to continue their story, or give them some kind of appropriate prompt to continue. And sometimes this can even be as simple as "you can continue," right? Allow the client to tell their story in whatever manner or timeline feels appropriate to them, and then return later to ensure that you correctly understood the timeline or ask for additional details that you need. If the client seems hesitant to share something specific, be transparent about why you need that information. Why is it going to be helpful for their case? but then give them the option whether to disclose. It's truly their choice. They guide their representation. If they know that this information is going to be helpful to their case, but they don't want to give it to you, that's them guiding their representation. Okay. You can also give them the option to talk about it on a later day. Sometimes you bring something up, they weren't necessarily expecting it. And so again, giving them that space, that predictability to say, that's okay, we don't have to talk about it today. I know it wasn't something that you were expecting. Let's talk about it the next time we meet. That might let them, give them time to be ready to talk about that. And to help with memory, time markers or seasons or events can be very effective. So for example, if a client's having a hard time remembering when an event occurred, you can ask them if it was near a holiday, whether it was hot or cold outside. If they've told you about another event, you could ask them about it in proximity to that event if they knew when that one happened. So kind of comparing things is helpful to clients. Repetition, I've talked about this already. This can be key to client understanding, but I'm going to repeat the repetition importance again. Recap at the end of meetings, review what's coming in their case, and if it's safe for them to take something home in writing, write key points down for them to take home so that they can continue mulling over it even after they've left your office, so that they don't have to call you the next day and say, what is it that you told me to think about while between our next 2 meetings? But it also just gives them the time and space to think about it in a more comfortable setting. Okay. The next tactic is client control. We've talked about this a lot, and giving the client control over their representation is a critical part of trauma-informed stance. The trauma that they have experienced has often stripped them of their control over their own lives, and we do not want to perpetuate this. But often, clients have preconceived notions about the hierarchical structures of an attorney-client relationship. Society builds certain, watch TV and see how a client or an attorney connects with their client. There's these certain things that clients may believe about the relationship between an attorney and client. And we want to break down these hierarchical structures, explaining to the client that in fact, they are in charge of their case. So they are in charge of their case. We also have to maintain the awareness of the power of suggestibility that we have based on our title as attorney. So again, there's a lot of privilege that we have with our title as attorney. And if we suggest a certain tactic or say that we think a certain tactic is best, the client may choose that tactic, even if they think a different tactic would be better for them. And so we need to actively empower our clients to use their agency. That doesn't mean that we can't suggest certain tactics to clients or tell them that they're best. We just need to do it in a correct timing and be careful of the way that we suggest it. I often tell clients, if it comes down to me saying what I think is best, I say, well, if you have asked me 1,400 times, I will tell you what I think is best. But remember that I don't know your daily life. I can't predict for you what's going to be best for you in your daily life. You are the only one that has that knowledge. Okay. So my knowledge, I'm basing my best case outcome based on my knowledge of your life, but I'm not you. I don't have all the knowledge of your life. You are the only one that has the knowledge to truly make the decision for the best interest in your case. Okay. So you want to actively empower clients to use their agency. Ask them what they think is best for them. So for example, maybe even how to avoid triggering during a trial, if there's something that we can do during the trial to help them avoid triggering. Validate their strengths. Again, only they know what's best for their case. Respect their decisions. Give the clients the option to disclose certain information, explaining how disclosing or not disclosing may affect their case, and then letting them make that choice. So for example, sometimes clients may be very resistant to painting themselves as a victim, but you feel that in their custody case, for example, showing what one spouse has done to another would help them in their custody case. Explain, I understand that you're a strong person and that it's important to you that you've been so tough despite everything that you've gone through. But I think I can do a better job of achieving your goal of getting primary legal custody for your children if you allow me to show the court and tell the court about how your spouse has treated you and how that was hard for you. And if they still say, no, I don't want to be painted as the victim, respect their choice. Be clear about your ethical duties of confidentiality. And if there's extra confidentiality provisions that may apply to a given case, make sure to be clear about that. It helps them understand that what you're telling them is not going to go anywhere without their control, without them saying that it's okay. And lay out the options for your client clearly. I have a little chart here, but you may want to use flow charts. You may want to use role playing. You may want to use other kinds of diagrams, just anything to help the client clearly understand their options. Invariably, clients are going to ask, what do you think I should do? And so again, take care in responding to this question. You can tell them what you think is best to achieve their goals, but continue to stress that only they know what is best for them based on their daily experiences and their situation. Your expertise is the law. Your client's expertise is their knowledge of their lives and their experiences and their needs. Finally, we have proactive support of a client. So thinking ahead to triggering. This is our final trauma-informed stance. In discussing this, we're going to focus on triggering situations. So how to avoid triggers and how to respond when a client is triggered. The information on this slide is a repeat of what Kayla talked to us about earlier, because I just wanted to make sure that we all took a moment to remind ourselves of things that are common triggers, and then also the signs of when a client is being triggered, so that we can, the tactics that I'm about to tell you, these are the types of situations that you may want to use them in. So triggering can occur anytime anything in the environment reminds a trauma survivor of their traumatic event. And so unpredictability, that's why we want to be as predictable as possible. Even transition. So sometimes in your client meetings, when you're transitioning from one topic to another, you need to take care in your transition. If they feel like they're losing control over their situation, if they're feeling vulnerable or lonely or rejected, maybe you canceled a meeting on them at the last minute and now they're coming in and they feel like you've rejected them. If there's any type of sensory overload in the environment, if they're having to face confrontation, which unfortunately in the law, they might having to be facing confrontation, right? Confrontation could just be making a choice about confrontation with another litigant. When they're telling you their story, they might become embarrassed or feel ashamed. And then even sometimes positive attention or intimacy. So even if you're, telling them how strong you think they are or how great they're doing, even that could be triggering to them, okay? And so take care to think of these signs of being triggered. They may jump up or lash out at you, and they might be angry with you, even though they're not actually angry with you, but that might be what they appear to be. They might have difficulty tracking your questions. So if you ask them a question, they might answer something that is completely off topic because maybe that's what's in their brain right then. They might have other difficulties in communicating or expressing their thoughts. They might give some kind of very brief clipped narrative or say that they don't remember, even though you know that they do because you've talked about it in the past and now you're just trying to get some more details. Or they may just shut down. They may look like they have a flat affect, or they appear like they're kind of somewhere else, like they're not in their office with you, okay? So how can we avoid triggering? That's what we're going to talk about first. Next, we're going to talk about how to respond to triggering, because inevitably it will happen, but let's first talk about how to avoid it. First, we want to create an environment that is calm and soothing. This encompasses numerous things. You want to make sure that the physical space you use doesn't have triggering elements in it. So for example, too much clutter or abstract art, or even art that you think is soothing but could be triggering to clients. So generally we think of pictures of nature, the colors purple, blue, and green. These are the soothing, natural things. But you also want to, no matter what space you're in, you want to offer the client options of where to sit within the physical space. Don't tell them to sit in a specific chair. You're taking their power and control away when you do that. Let them choose. You want to try to minimize power differentials in the seating arrangement. So if you're sitting across your client at a desk, maybe your chair is higher than theirs, maybe you're sitting like this, that sends the message that you are in charge and you're taking away their power again, just by the way in the space that you're sitting in, okay? Sitting at an angle from the client or potentially side by side, although for me that's hard for taking notes and looking the client in the eye. But nonetheless, that potentially that angle creates a feeling of equity in the relationship between you and the client. You also need to make sure to give the client decision-making power in who attends the meeting. And for me, this is something that I find really difficult. I would always prefer to meet with the client alone to avoid any potential outside influence and to preserve privilege with the client. But a client may feel more comfortable speaking to you with a friend with them, an advocate with them, whoever it is. You have to give the client the choice in the matter after explaining the legal consequences. So like the potential loss of privilege. If there are times where you think that you really need to be alone with your client, tell them, I just want 5 minutes alone with you. Like if you think that the other person that they're bringing into the room with them is their abuser or is an abuser, it's okay to take some time with them, but generally make sure to give them the opportunity to determine who attends the meeting. Okay. You also want to make sure and take care to use appropriate body language and verbal communication. Do not touch your client without their permission. Touching them could be a trigger for them. Even if you're trying to soothe them, like a soothing pat on the shoulder, that could be triggering to them. Avoid crossing your arms or putting your hands on your hips, right? These power stance or in your pockets. These are things you want to do in court in front of the judge, but not in your office with your client. Think about your facial expressions. Try to use gentle eye contact. You don't want to be staring your client down the entire time. And you're probably going to be taking some notes, but try to look up from time to time to establish some gentle eye contact with your client. And affirm how difficult it is for the client to talk about certain subjects. That in and of itself can be critical, just letting them know that you know that it's hard to talk about these topics. Again, give the client control over when and whether to disclose sensitive information. If they don't want to today, they can do it another day. If they understand the legal consequences of not disclosing to you at all, they can make that choice too. And then finally, you're going to want to use grounding techniques. Check in with the client throughout the meeting. Offer them breaks. They might not take them, but offer them breaks and a chance to get up and move. Sometimes just moving and changing the scenery helps to, bring them back to a calming space. You may want to offer them tangible items like water or tissues or even a stress ball, right? So that they can just keep their hands occupied. I often have something in my hands. Usually actually when I'm doing trainings like this, I have something in my hands that I'm twirling or doing. And so some people just find that very calming. And then finally, take deep breaths together. Don't just tell your client to take a deep breath, because if you say take a deep breath, they're going to go, and that's going to be their deep breath. Help to model it for them. So, right? You could even, we don't have time today, but there are numerous breathing techniques. One is the 4-2-6 technique. You can look those up and practice those with your client if you think that that will help ground them. All right. So like I mentioned, inevitably, unfortunately, our representation is likely to trigger our clients, or they're likely to be triggered by something. Whoa, okay there. I press buttons. All right. Apologies. So unfortunately, in the legal landscape, our clients are likely to be triggered at some point. Okay. And so we need to know how to react to that triggering as well. The first thing to note is that it's important that we don't just ignore what the client is feeling and experiencing and just try to move on. You cannot do that. That does not work. Take the time to recognize and respond. The first thing you need to do is to avoid escalating the situation and respond calmly. And that can be difficult if somebody is yelling at you, telling you that it's your fault, because that might be the way that their trauma comes out. But do not raise your voice. Do not become defensive or confrontational. Even if the client is lashing out at you and telling you that something is your fault, you need to understand that it might not be a personal attack against you. And even if it is a personal attack against you, this is not the time to defend yourself. You can do that in a few moments when they've returned to baseline, okay? If it's necessary. Don't startle the client. Avoid quick movements. If you're going to reach for that stress ball, don't jerk for it. Smoothly grab it, okay? Speak in slow and short sentences. When a client has been triggered, it's like they're experiencing their trauma all over again. So that amygdala is lighting up, okay? And the effects of trauma are even more pronounced than they might normally be. So they might have difficulty in understanding things, taking in information, or communicating their thoughts to you. You also want to validate the client's feelings, including their frustrations with you or the system. The system is often unfair. We are agents of that system as lawyers. Even though we are trying to obtain the best outcome for our clients, we're still restrained by the legal structure, and that's frustrating to our clients, and often to us. But it's important to let the client know that the system can be unfair and that you're constrained by the system, not in a defensive way, because we noted earlier, you don't need to be defensive, but express empathy about the client's frustrations. Once you have calmly reacted, you want to address the triggering event. Tell the client that their reaction is normal and that there's not something wrong with them. A lot of times people who have experienced trauma think that lashing out like that or becoming triggered in some way means something is wrong with them. Let them know that that's a normal trauma response, okay? Then remind the client that they are safe with you and that you are going to wait until they are ready to proceed. So again, offer a break. Ask them if they want some water. Ask them if they need to get up and walk around. And then once the client is ready, so they return to their baseline, ask what it was that triggered them, or help them problem solve what it was that triggered them. They might not be able to directly tell you what it was that triggered them, but try to go back and think about what you were talking about to see if you can identify the trigger. And then tell them that you will also try to avoid that trigger in the future, or at least give them notice of that trigger in the future if it's going to have to come up. Again, that predictability. And reassure them that they can let you know if they are feeling uncomfortable. Okay. I am out of time. So even though I would love to go over parallel universe thinking with you, as well as avoiding judgment and questioning, I hope that you can all take a moment to look through these slides. I particularly love parallel universe thinking.
Excuse me, Mary, can you announce the second code word?
Yep, I'm about to.
Thank you.
No problem. So parallel universe thinking, this is really helping us to avoid hasty decisions and to consider the multiple explanations for our client's behavior by focusing on the facts and brainstorming alternative explanations for their behavior or their speech. And then again, when you're questioning your clients, you want to avoid indicating that you are judging them by the way that you ask your questions. And so you might not be intending to judge them. You might not think that you are judging them, but they could perceive that you are judging them. And so you want to find some non-judgmental corollaries to the questions. And I have some questions here that could indicate judgment to a client. And so I would encourage you to look at these and think about some questions that would not, first of all, think about why these would express judgment, and then think about some non-judgmental corollaries. But we will take our break. Our second code is self-care, because that's how important it is that you engage in self-care. Self-care is the bedrock of the trauma-informed lawyer. So that is our code number 2. And I'm going to take a shortened break and we'll come back at 6:07.
Mary, just one quick question before the break. There's a couple of questions that are related to what you discussed. Do you want to wait until later to take those questions after the break?
Let's go ahead and take the break and take them after we do the demonstrations.
Okay.
So I will see everyone back here at 6:07. Okay, everyone, I'm going to bring us back from our break. Thank you so much. I hope, again, you got some time to stretch. I went out in my yard again, stretched in the yard. My neighbors still think I'm weird. Nothing's changed. So we're going to take some time to do some demonstrations right now to kind of show some of the tactics that we've been talking about throughout this program. And so we're going to have mock clients and not mock lawyers, because they're real lawyers, but they are mock our lawyers. And we're going to use a little bit of role playing, some demonstrations to show how some of these tactics work in practice. So Julina is going to be our first attorney, and Kayla is going to be our first client. I will let you two take it away, and Lorelai, I think it'd be best if you and I turn off our videos.
Mary, and thank you everyone for speaking on this important topic and for contributing your thoughts. So for this demonstration, Kayla and I will be role-playing a client and attorney. For the purpose of this demonstration, the client will be named Anna, and we are going to pretend that we've met before to discuss Anna's domestic violence case in the context of an immigration application under the Violence Against Women Act. VAWA. So this will be like our second or third meeting. And so we've gone through sort of the introductions prior, and now we're going to continue our discussion about Anna's case. All right. Hi, Anna. How are you doing today?
Okay.
It's been a while since we last talked. How has Davey been liking his new school?
Well, he loves it. He's made a lot of new friends. English is his favorite class right now.
That's wonderful to hear. I'm so glad he's doing well, and it's really nice to see you again. Would you like some water before we begin today?
Yes, please.
Of course. Here's your water.
Thank you.
Thank you again for taking the time to speak with me. I know you're very busy. Now, last time we spoke about your immigration petition under the Violence Against Women Act.
Yes, I remember.
And we had talked about painting a picture of your life, especially your marriage, for the immigration officer. We want them to get to know you as a person.
Right.
So last time you told me about your childhood.
Yeah.
And you told me about your mother, your father, and your sisters.
Yes, that's correct.
You also told me about your neighborhood, where you grew up, and your friends in school.
Yeah, I have really great memories of my childhood.
And we left off when talking about how you met your husband, Dan.
Right.
Would it be all right if we talked about that a little bit more today?
Sure, I guess.
I'm sorry, I know that this is a difficult topic for you. As I mentioned in our first meeting, we need to explain to the immigration officer how your relationship developed and how your experiences qualify you for VAWA. So we'll take it slow and maybe just talk about the early parts of your relationship today. Would that be okay?
Okay, I think I can do that.
Okay, and you can let me know if you need a break anytime.
Okay.
All right, thank you, Anna. So first off, can you tell me when you first met Dan?
We met during my senior year in college. I think it was around 2010. We had met on a dating site. He was also a senior at my school.
And what was your early relationship like?
I was actually the one to message Dan first on the dating website. We went on 2 dates before we decided to be together. We were so in love. He was kind and thoughtful. I introduced him to my family, and everyone just thought he was this really good, great guy.
How long were you dating for?
9 months. And then he proposed, and we got married in 2011. After we got married, everything was good for the first couple of months. We had graduated from school. I had a good job to support us. Dan did have trouble finding a job, and that really stressed him out a lot.
What did he do when he was stressed?
At first, he was just short-tempered. He would complain when doing chores like cleaning or cooking or taking the trash or the dogs out. But he soon started directing his anger at me. He started yelling at me a lot.
Would you feel comfortable sharing some of the things that he would say to you?
Yeah, I want to get this out. He yelled at me if I was late getting home from work, especially if I told him that I was out with my work friends. He got upset when I talked about my work at home. My colleagues threw me a birthday party in my first year there, and Dan was angry when I got home. He told me I was wasting my time and they didn't actually care about me. He said he was the only person that cared about me.
I'm so sorry to hear about that. How did all those words make you feel at the time?
Guilty, angry, mad. He made me feel like I shouldn't have been doing my best at work or trying hard to make friends. I had to go to work because he didn't have a job. How are we going to live? I was proud of my accomplishments at work. I was happy to have made new friends, but that wasn't the worst of it.
Would you feel comfortable telling me a little bit more about that?
Sure. When I became pregnant with Davy, it got a lot worse. Dan was working part-time at a grocery store while trying to find a stable job. I'd been promoted. I was so excited for the baby. And there was one night when I got home from work.
It's okay, Anna. I know how hard this must be for you to talk about. Do you want to take a break by any chance?
Yeah, could you get me another cup of water?
Yeah, of course. I'll go get that for you. And in the meantime, just feel free to take as much time as you need. All right, a couple minutes later. All right, here you go. Here's your water.
Thank you. I think we can proceed now.
Please.
So one night I had gotten home after work and Dan met me at the door. I don't know what set him off. He must have been mad at me that I got home so late. He hit me out of nowhere, slapped me in the face, and he said some awful, awful things. Do I really have to talk about this right now?
We don't have to go through this now if you don't want to, Anna. And I'm sorry that I'm asking you these questions about this terrible experience.
I do, but I just don't know how. And what if Dan finds out?
I understand, and rest assured that Dan will not know. Like we discussed in our first meeting, I am your attorney, not his attorney, and he won't even know that you've filed a VAWA petition. And remember that our conversations are protected by attorney-client privilege, just between you and me. So I won't disclose any information at all to anyone else unless you give me the permission to do so.
Okay, thank you.
All right, thank you. That was the end of our demonstration. Mary, would you like me to sort of talk a little bit about it?
Yeah, that'd be great.
Okay, great. So I tried to model some of the techniques that we learned today that our experts shared, and you'll maybe notice that I tried to navigate the conversation using the flow of the client, and whatever topics or details the client mentioned, those were the details that I hooked onto and asked follow-up questions about. So it's very important to start very open-endedly, like that T-funnel technique that Mary talked about, starting with questions that were more, I think, low stakes for the client to respond to, reminding her about what we had talked about in our last conversation and giving her a roadmap that we were going to talk about her relationship with her abusive husband in this conversation. You might have noticed that I tried to let the client take a little bit of control over how far in that relationship she wanted to delve into. I had suggested maybe just speaking about the early parts about how they met and the early years of the relationship, but the client actually really wanted to pick up on that. And she ended up speaking about after they got married, the abuse that she suffered before she was pregnant, and then the physical abuse she suffered after she became pregnant. So there was a lot that the client actually wanted to unload and express and articulate, which is totally fine. And so you ask follow-up questions based on that. If this were in a real client setting, I would probably devote more time also to going over the legal factors of her case and explaining why it's important that I am asking her these questions about this very difficult topic. I would also, be able to hopefully to gauge more about body language if we were in person, and reading her facial expressions to see how she was reacting to the types of questions that I mentioned. And then if you notice that the client may benefit from a break or just a little bit of a break, a water break or stretching like we were talking about. I tried to do that as well to give her some time to decompress and to process the topic that we've been talking about, and maybe to mentally think about, where she wants to take the conversation next. And again, we left the discussion so that, we're going to have further meetings. You're not going to be able to get all the information from just one client meeting, as we talked about. And if you push your client too far in that meeting, you're going to automatically cut off that trust forming relationship that you're working so hard to really cement. So these meetings often take 4, 5, 6, sometimes even more. We've talked about so much this evening about how memory can be impacted by trauma, and that oftentimes, most times, they're not intentionally trying to hide, facts from you. They're not trying to be difficult, but it's just sometimes hard for them to process details or remember the details at different times in their lives. So trying to just stay at the pace of the client to see what topics she wanted to delve more deeply into, trying to avoid triggering her by forcing her to speak on any one issue, and then closing the conversation with reassuring her again that I know this conversation is difficult, but your abuser will not know. In fact, nobody will know that we've been talking and that I'm representing you in this valid petition because I am your attorney. So making her feel a little bit more reassured in a moment of maybe panic or confusion or fear.
Awesome. Thank you so much, Julina. And now, Julina and Kayla, I'll ask you to turn off your cameras while Lorelei and I do a demonstration. Lorelei will play the attorney, and so she gets to be in her comfort zone, but I had to play the client and be outside of my comfort zone.
Great. Hi, Mary. Oh, sorry. For background, Mary is detained, and we have a bond hearing tomorrow, and I represent her in bond only, not for the full merits of the case. Hi, Mary. How are you doing today?
Yeah, same old, same old.
Yeah, I know. Things must be really hard. I can't imagine what you're going through. Well, I don't want to take up too much of your time, and I want to get through this as painless as possible given the circumstances. But I came today to talk because you have your bond hearing tomorrow. Is it okay if we talk a little bit about it and prepare for it?
Yes, I'm so ready to get out of here.
Yeah, no, I totally hear you. So I'll try to, cut to the basics and make sure that you know the essentials of what's going to happen tomorrow. So as we talked about before, I had filed a motion for you to be released on bond. I'm representing you in bond only, not in any other immigration matter like your asylum application or anything like that. Tomorrow we have the hearing where the judge is going to decide whether or not he's going to grant you a bond, so that way you can get out on bond. And now it is possible that if we don't get granted bond tomorrow, that the judge will deny the bond. And if he denies the bond, then we have two options. We can either accept the denial and then try to get you out of here and back home as quickly as possible. Or we can try to appeal the denial. But appealing the denial is a bit of a process. Does everything make sense so far? Do you know what an appeal is generally?
Yeah, I mean, basically appeal is saying this judge made a bad decision, somebody should change it.
Right, exactly. And so in this case, the immigration judge who's be making the first decision tomorrow. So if he denies, then the judge is going to ask you, hey, do you want to reserve appeal? Now, by reserve appeal, and sorry, he's not going to ask you, he's going to ask me for you. And so when he asks that question about, do you want to reserve appeal? He's not asking, do you absolutely want to file appeal? He's asking, do you want to keep the option of filing an appeal after the hearing tomorrow? And what that means is it means that ICE cannot deport you for 30 days because they give you a 30-day window to file your appeal. And that goes to a different court that's called the Board of Immigration Appeals in Virginia. Does everything make sense so far? Do you have any questions?
So if I reserve appeal, then I'm in detention for at least 30 more days.
Exactly. And so that's the real crux of the issue that we have right here. Now, I know that this detention center is horrible. It's horrible for your health. It's horrible for your mental health. It's horrible for everything. But if we deny if our bond is denied tomorrow, then you're basically stuck with two options. Either try to go back home as quickly as possible and give up options to appeal, or we can, talk about reserving appeal. Now, there's one other thing that I want to talk about. Now,
Wait,
if you remember,
so you're telling me that my only two options are to either go back to a country where I'm going to be killed, or to stay in this detention center where they treat me like an animal?
So just as a reminder, and I know that this is really hard and the system is really messed up, but what we're talking about is your bond specifically, not your full immigration case, like your asylum application. That's filed separately in what is called your case in chief in immigration court. Your bond case is something that's separate. Think of it as kind of like a smaller case that gets decided more quickly. And so what I'm saying is you're not necessarily going to get an order of removal tomorrow, because the bond is either going to be granted or it's going to be denied. But if it's denied, then you have two options. Either try to reserve appeal and appeal your case, or give up and say, you know what, Judge, fine, I accept your denial of my bond.
Okay, so what happens if I lose the bond?
So if you lose your bond and you accept the denial, then you can try to get deported as quickly as possible. If you lose the bond and you want to reserve appeal, you cannot be deported for at least 30 days. And during that time,
my appeal?
I'm sorry?
Are you going to represent me in my appeal?
And so that was the next thing that I wanted to talk about. So during those 30 days, you have time to think about if you want to appeal and to put your appeal together. Usually you just need kind of like a bare bones filing within those first 30 days. Now, if you remember at the beginning of our meeting, I reminded you that my representation of you was limited to just the bond. I'm not representing you in your immigration case. And also, if you remember when we first met, I can't promise to do appeals from the get-go. But let me explain why. I have a lot of clients, and people in my office, we all have a lot of clients. And unfortunately, the immigration system is really bad. And sometimes we lose a lot of cases because the system's really stacked against our clients. Now, because of that, we have to be very careful about who we promise services to, because if we take on too many clients, then we're going to start doing a bad job for everybody. And so an appeal is a lot of work. And so if we sign on and say, hey, we're going to do someone's appeal, then we have to make that full commitment and do a good job. And if we do a bad job after already signing on someone's case as their attorney, that can really mess up their case in the future if we, do a bad job because we were stretched thin, right? And so that's why we can't promise to do appeals at the outset. Now, what I can promise you to do, that I will do, is if you decide that you do want to reserve appeal, I will talk to my supervisors and see if we have capacity to take your case on for appeal. And if we don't have capacity, I will definitely do my very best to try to find another attorney to refer you to, or maybe a pro bono project that we can refer you to try to find someone to help you with your case. But I think what I really want to focus on for just a moment, though, is the thought that if you reserve appeal, you can stay detained for another 30 days. And if you don't reserve appeal, if your case is denied, you don't have to detained those 30 days. We cannot predict when ICE will deport you. It could be quicker than 30 days. It might not be quicker than 30 days. But at the end of the day, this is your choice in your life. And I know it's terrible. And I know detention is so incredibly unfair. But I wanted to make sure that you kind of understood what could happen tomorrow if your bond was denied. Now, hopefully it's granted and you're out and home free this week, right? But we still need a plan for the worst case scenario, just in case.
All right, we'll break it there, and I will give Lorelai the opportunity to explain her strategies.
Yes, absolutely. Mary did a very good job at being the client. That reminded me a lot of my detention work. So for me, one of the things that I think is most important is that it's very, very important to communicate the complexities and the nuances of the legal situation to your clients in words that they understand, but in a manner that is not condescending or patronizing. And so if I were to just say, you have 30 days to reserve appeal, do you want to reserve or not? That's not going to make any sense to most people in detention. What will make sense is, oh shit, if I reserve appeal, I'm gonna be locked up for 30 more days versus not locked up. And I say this because in my detention work, some of the most traumatic incidents, according to my clients, were when attorneys reserved appeal when they did not want appeal to be reserved because it caused them to be detained for an additional 30 days. And that was the worst experience that our clients had with us, right? And so this hypo is extremely important because from an attorney's perspective, this seems like a no-brainer. We always reserve appeal, right? Because we always care about the legal situation. We always care about the legal remedy. And that's not true for the lived experience, right? That's not true. It's not necessarily worth staying detained for 30 days, right? And the other thing that I would caution you guys to also remember, just kind of generally, is just remember that if you get a bad decision or a difficult decision with an attorney on the record, it is so much harder to then do a motion to reopen or something else later on than if they were pro se. And that I say because it's something that I tell myself quite frequently to remember. This is why my capacity matters, right? If I'm going to take on a bunch of cases and mess up their appeals because I was stretched thin, they are screwed over more than if I had just left them alone and not tried to meddle in their case. Because you can often do reopening type strategies, you know, without counsel, but not necessarily when someone was represented. And then I think the other thing to remember too is, especially in this situation, because Mary does such a good job, I think that there's a lot of attorneys who could get very defensive in the moment and be like, why are you being so difficult? I'm trying to help you and prepare you for your case, and you keep on interrupting me when I'm trying to explain something to you, right? And so it's very important to remember, though, again, I have to center Mary in my conversation. She's upset and frustrated. She's the one who's detained, not me. So if anyone needs to show anyone grace and give someone a little bit more space to just feel and exist a bit without getting defensive, I'm going to be that person trying to give that space to her, right? Because that is the privilege that I hold in this situation. Those are kind of the main things that I think I did.
Because I was about to cut you off because we're right at 6:30. If the panelists are okay, we are available to stay on for a few minutes of question and answering, but I do know that some people, that 6:30 timeline might be tight, so I wanted to at least stop our formal program. Thank you all so much for attending today, but like I said, we will continue on into question and answering if for those who want to stay. And Jaya, I think some comments might have come through.
Yeah, there was a question way back, Mary, when you were talking about transparency. And I think that the question was, have you ever moved to be relieved of representation because of a breakdown in the attorney-client relationship? And how did you handle that situation with your client? And would you have done anything differently looking back?
I have done that. It was mutual between my client and I, and so that might be different than when you are withdrawing from representation, but your client wants you to stay on. But it was difficult. We came to a point where we did not agree on how to move forward with her case. She was unfortunately suffering from some significant mental health disorders that she wasn't seeking treatment for, and it made it very difficult for me to be able to represent her. But again, I was transparent with her throughout the process. I told her why I disagreed and why I didn't think that I could continue representing her, because her goals that she was expressing to me were so far outside of my comfort zone, my ethical comfort zone as an attorney. And I explained that to her. I was very transparent about it, and it made things go as smoothly as they can go when you're breaking down a relationship. I'm not going to say it was all fun.
And I would just add also that I think, you know, so many of us are very conflict avoidance. And so we're like, oh my God, I have to break up with a client. What am I going to do? It sounds terrifying and horrible, right? It is actually the best thing ever to speak directly with your clients about these issues, because when we hesitate to have that direct conversation with them, it can come off as very paternalistic and very patronizing, and that is not healthy for any relationship. And what I have found is that a lot of client relationships are actually reparable. They're not actually so far gone that you need to completely break up, right? I've had plenty of clients where I think that, you know, perhaps if they were with another colleague, the relationship wouldn't have worked out, but I was able to engage in a direct conversation with my client and their mental health and how it was impacting our ability to work together on the case. And that direct conversation was very helpful because, you know, and I think this is another thing that perhaps like neurotypical folks don't always realize. Those of us who are neuroatypical for any reason, including PTSD, we know we're neuroatypical, okay? And so we're expecting these direct conversations about these issues because we have to navigate those conversations all the time anyways.
Thank you. Jelena, did you have anything to add or to that? The next comment is, or question is about the offering of a tissue to someone who is having an emotional response. And the question is, you know, does this demonstrate, you know, emotion in a place where crying is not welcome? Is there, you know, the question says, or the speaker says that a suggestion they've heard is that the tissue should be placed in an identifiable place. So if it's needed, that person can then access the tissue. Do you have any suggestions or thoughts on this?
Yeah, I usually have the tissue box always there. There have been a few rare occasions where I ran out of tissues before the meeting and didn't realize it, and then I did have to go get them. In a situation where I'm leaving the office to go get tissues or moving tissues from one space to another, what I usually do is I ask them if they want a tissue before I make the move, because that indicates that they have the choice not to get it. And so it's okay if they want to keep crying without a tissue, right? And so I think that could be one way to kind of mitigate that if you need to offer the tissue. But I do usually keep mine in between, you know, like in the space where my clients will be sitting so that they can reach out to them, but also at a place where it's accessible to me so that it looks like it could be for either of us.
I'll also say it's frequently not about the tissue either, right? Like I'm thinking about my own responses as a trauma survivor and also the clients that I've grown really, really close with and have learned how they cope with things. And oftentimes that moment when we need a tissue, it's not because we feel shame or want to cover up our tears or something like that. Sometimes we just need a moment to remember how to put our brain back together, right? Because we're so dissociated and our brain's kind of going all over the place, and having something to fixate on for a second, whether it be a glass of water or a tissue or a fidget toy, can help ground us again, right? And so it's really important to remember that a lot of these issues are also kind of very nuanced and can vary with cultures, right? Like I'm familiar with some cultures where if I didn't offer a tissue, that would be the worst thing ever, right? And so I think the more important thing, and you know, Mary mentioned this earlier, like this is not formulaic, but if you develop authentic relationships with your clients, your little actions are not going to be so meaningful because it's the relationship that holds you together, not where you put the tissue box.
What a great way to end this CLE. This was really wonderful. Thank you all. Thank you to the wonderful speakers for being so informative, and as one commentator indicated, also very depressing at times, CLE, but that is the kind of work that you do and that we do. So thank you again.
Thank you all for attending. And the CLE, to get the CLE certification, the materials had the form to fill out. There is a space for 3 CLE codes, but there were only 2. This is a general form that they use for numerous CLEs. So sometimes CLEs have more form or more codes, but just fill those out and return them to Lisa Ravage. Her email address was in the materials. Thank you all.
Thank you.